I'm James Johnson. I'm the chair of the history department. This lecture is made possible through an endowment which was established in the 1940s. Gaspar G. Bacon was a Boston attorney. He was president of the Massachusetts State Senate, lieutenant governor of Massachusetts, and a candidate for governor in 1934, and defeated by James Michael Curley. He was also a lecturer at Boston University. He was a scholar, and among his books was the 1928 work published by Harvard University Press, The Constitution of the United States in Some of Its Fundamental Aspects. He specified in this grant that this annual lecture be devoted to the U.S. Constitution. And our guest this year is one of the country's leading scholars on the U.S. Constitution, Melissa Murray. She is the Frederick I. and Grace Stokes Professor at Law at New York University. She teaches constitutional law and family law. She teaches a regular reading seminar on the legal, social, and cultural construction of motherhood in America. That seminar is called Mothers in Law, with no hyphens. She writes on reproductive rights and justice, law and sexuality, family law and criminal law. Melissa Murray appears regularly in the national print and television media with her views on the U.S. Supreme Court, its justices, and its decisions. It's an honor to have Professor Murray with us today. Her topic is Dobbs, Democracy, and Distrust.
Let me echo that thanks to all of you for your patience today. I don't even know what to say. I got on board the flight this afternoon expecting an on-time departure or maybe a few delays, and 2 hours later, there I was still at Newark, and I called my husband. I was like, the plane still isn't here, and he just joked. He's like, it's probably Justice Thomas. But I was flying commercial, so I knew that wasn't it. But it is a delight to have persisted nonetheless and to be here with you all today. And I'm very grateful to Professor Johnson and the History Department for inviting me to be the Bacon Lecturer this year. And I'm especially grateful to Katie Steinberg, who has organized everything, including driving to the airport to scoop me up and navigating Boston traffic at rush hour to get me here. I'm only an hour late. So thank you so much for having me back. In keeping with this lecture's theme, I am going to talk a little bit about the Constitution, more specifically about constitutional protections for reproductive rights, as well as their relationship to questions of democracy. And the lecture is drawn from an article that I have co-authored with my colleague, Professor Catherine Shaw of Cardozo Law School, and the article is forthcoming in the Harvard Law Review. It won't be published until January, but you can get a preview of it and where we're headed with this. Not surprisingly, the article focuses on Dobbs versus Jackson Women's Health Organization, which, as you know, is the June 24th, 2022 decision of the United States Supreme Court overruling Roe versus Wade and Planned Parenthood versus Casey. I want to just start there. It's unusual for the Supreme Court to unrule a decision, certainly one with such a storied history as Roe and Casey. The abortion issue has been considered by the court multiple times, and it has always survived until June 24th, 2022. So what does it mean for the court to withdraw constitutional rights, and on what basis do they justify their decision to do so? No. Justice Samuel Alito's majority opinion in Dobbs repeatedly claimed that the court's 1973 decision in Roe versus Wade had preempted debate at the state level on the question of abortion rights. And Justice Alito, in that opinion, insisted that this kind of democratic deliberation, this interrupted or disrupted democratic deliberation, was and should be the proper mechanism for resolving the competing interests at stake in the abortion debate. And according to Justice Alito in this majority opinion, Roe, and then subsequently Casey, had wrested this vexed issue of abortion from the people It had misguidedly enshrined abortion as a fundamental right, and in doing so had cut off the people's right to debate this question amongst themselves. On this account, overruling Roe and Casey was not an act of judicial overreach. It was doing no more than rightfully restoring the question of abortion to the people and the prospect of ongoing democratic deliberation. Now, this invocation of democratic deliberation obviously has enormous rhetorical power. It allows the Dobbs majority to lay waste to decades' worth of precedent while rebutting charges of judicial imperialism. And indeed, it casts the court and the majority in the posture of juridical heroes, vanquishing this lost democratic deliberation and restoring the people's voices. But in this lecture, I want to interrogate this claim that Dobbs does no more than vindicate principles of democratic deliberation and democracy. I want to examine both the opinion's reliance on this narrative of disrupted democratic deliberation, as well as the intellectual pedigree of that argument, and the opinion's substantive vision of democracy, and the purposes for which the court chose to invoke the values and vernacular of democracy, and what that might mean as we proceed into this post-Dobbs future. So, by way of a roadmap, I will first consider the majority's reliance on the argument that Roe and later Casey disrupted ongoing democratic deliberation of the abortion issue. And as I'll explain, the Dobbs majority insisted that this critique of Roe as disrupting ongoing democratic deliberation had always been present from 1973 forward. But as we explain in the paper, that's not true. In the immediate aftermath of Roe, the issue that was most on individuals' minds was the question of fundamental rights. It was only years later, through a series of legal and political developments aimed at discrediting and ultimately toppling Roe and then later Casey, that this question linking Roe to disrupted democratic deliberation surfaced and was fully elaborated. But in toppling Roe and Casey, the reliance on this narrative of disrupted democratic deliberation has had not only undeniable rhetorical power, insulating the court from critique, it has profound consequences jurisprudentially for the court going forward. And I'll talk about those. Having identified those intellectual origins of the democratic deliberation argument and its contemporary consequences, I then want to pivot to consider the Dobbs majority's vision of democratic deliberation. As we explain in the paper, although Dobbs traffics in the rhetoric of democracy, its conception of democracy is both internally inconsistent and extraordinarily myopic. This cramped conception of democracy is even more pronounced when considered alongside the court's recent and active interventions to distort and disrupt the electoral landscape. On this account, Dobbs purports to return the abortion question to the people and to democratic deliberation at the precise moment when the court's own actions have ensured that the political landscape is unlikely either to produce genuine deliberation or to yield widely desired outcomes. And finally, I'll consider what the Dobbs majority's preoccupation with democracy and democratic deliberation may mean for the future of reproductive freedom. A close examination of the opinion suggests that the majority may have deployed the values and vernacular of democracy not simply as a vehicle for restoring the abortion question to the people, but perhaps for more cynical purposes. As I explain, the majority's embrace of democracy and democratic deliberation not only shields the overruling of Roe and Casey from claims of judicial activism and overreach, it may also lay the groundwork for the eventual vindication and protection of fetal personhood. With that in mind, the Dobbs majority's purported state-by-state settlement of the abortion question is unlikely to be a lasting settlement. Indeed, aspects of the opinion suggest that this settlement is merely a way station en route to a more permanent resolution, the recognition of fetal personhood and the total and complete abolition of legal abortion in this country. So with that in mind, let me first start with this history of disrupted democratic deliberation and the narrative that has been associated with it. As I suggested in the roadmap, the Dobbs majority makes much of the notion that Roe and then later Casey disrupted ongoing debate at the state level over abortion rights. And critically, this notion of disrupted democratic engagement undergirds much of the majority's disdain for Roe, and it ultimately underwrites its decision to overrule this embattled 50-year-old precedent. The view that Roe disrupted ongoing democratic debate is such a well-worn trope in discussions of abortion rights that many, including the Dobbs majority, take for granted that this critique has always been associated with Roe. But is that correct? In the immediate wake of Roe, few people were focused on the decision as an example of frustrated popular debate. Instead, most critics focused on what they viewed as the court's misguided understanding of fundamental rights. The view that Roe disrupted ongoing democratic debate on abortion surfaced only briefly among the dissents in Roe versus Wade and its companion case, Doe versus Bolton, principally in Justice Byron White's dissent in Doe versus Bolton, in which he maintained that the court's decisions in Roe and later Doe stripped the people and the legislatures of the 50 states of the opportunity to weigh the relative importance of the continued existence and development of the fetus on the one hand against a spectrum of possible impacts on the mother on the other hand. Such a vexed and sensitive issue, White intoned, was better left with the people and the political processes. This is all we have of this democratic deliberation argument in Roe. And to be clear, although White made it quite forcefully in the dissent in Doe versus Bolton, he immediately left it behind. In the immediate aftermath of Roe, White, though he was alone in voicing this concern, abandoned this particular hobby horse to further the view that the real problem with Roe was that it had improperly identified abortion as a fundamental right. In this regard, Justice White was aligned with most juridical and scholarly critiques of Roe, including famously John Hart Ely's Yale Law Journal essays, The Wages of Crying Wolf, which lambasted the Roe Court's identification of a fundamental right to abortion. Now, this is all to say that at least in the immediate aftermath of Roe in 1973, the critiques of the decision focused principally on the process of divining and recognizing constitutional rights, not on the view that Roe had somehow disrupted the people's prerogative to decide certain issues. Indeed, it would take roughly 10 years for the critique of Roe as disrupting ongoing democratic deliberation on the abortion issue to surface concretely. But surface it did. In the mid-1980s, perhaps buoyed by the court's changing composition and the growing number of Roe skeptics among the new justices, Justice White reprised his earlier position that Roe had not only been wrongly decided, it had also usurped state legislative authority to debate this contested question. And he did so in a conscious attempt to connect democratic deliberation to a more controversial point: the court's obligation under the principle of stare decisis to adhere to settled precedents. Dissenting from the court's 1986 decision in Thornburg versus ACOG, Justice White reiterated his view that Roe, quote, departs from a proper understanding of the Constitution, end quote. But meaningfully, he also went further this time to make the case that stare decisis considerations were less weighty in circumstances where, as here, the court was exercising its judicial power to, quote, restore authority to its proper possessors by correcting constitutional decisions that, on reconsideration, are found to be mistaken, end quote. On this account, White was saying that the court need not follow the obligations of stare decisis and adhere to past precedents in circumstances like Roe, where the decision was viewed as usurping the people's prerogative to decide certain questions and improperly imposing judicial will. Now, White's position, with all of its implications for stare decisis, was well received by some members of the newly constituted court, but not a majority. But it had more immediate impact outside of the court and in the streets. In the immediate aftermath of Roe, the pro-life movement mobilized around various efforts to frontally attack the decision. These included a federal constitutional amendment that would overrule the decision, abolish abortion, and recognize and protect fetal life. But when these efforts stalled in the late 1970s, abortion opponents were forced to take up new strategies that would be more appealing to the broader public than the prospect of fetal personhood and abolishing abortion entirely, which is where the pro-life movement had begun. One strategy, championed by an enterprising young Department of Justice lawyer named Samuel Alito, involved chipping away at abortion access through regulations that made abortion increasingly difficult, expensive, or logistically complicated, both to provide and to access. But a second strategy sounded squarely in the register of democratic deliberation and focused squarely on the idea that Roe had involved impermissible judicial overreach on an issue that was properly reserved to the states. Now, to be sure, for many in the pro-life movement, the appeal to state-level democracy and determining the abortion question at the state level was a second-best intermediate position, one that was fundamentally incompatible with the substantive position that the fetus is a person and that any process that terminates a pregnancy is tantamount to murder. But with the prospect of such a constitutional amendment well out of reach, many in the pro-life movement viewed this intermediate position as a necessary way station on the path that could lead first to Roe's reversal and then ultimately to the elimination of all protections for abortion. And so, taking the long view, the pro-life movement hitched its wagon to the North Stars of democracy and democratic deliberation. And in Dobbs, we see this discursive strategy coming full circle, coming to fruition. The appeal to democracy that we see in Dobbs was a critical component of the majority's justification for overruling Roe and Casey. But as we explain, the appeal to democracy may have jurisprudential implications that go far beyond simply overruling these two precedents. As we know, Casey did more than simply reaffirm Roe. As then Judge, now Justice Brett Kavanaugh once famously said, Casey is precedent on precedent, which is to say, the Casey decision also identified a series of factors that courts should consider in determining whether to maintain fidelity to an extant precedent. Among the factors that Casey identified were 1, the quality of the earlier decision's reasoning, 2, its practical workability, 3, whether there were any reliance interests on the earlier decision, 4, any significant developments in related principles of law, or 5, the emergence of any new facts or special considerations that rob the old rule of significant application or justification. With these indicia in mind, there are 2 ways that we might understand the court's decision in Dobbs. One way to understand it, and the majority's preoccupation with democratic deliberation, is that the majority is putting forth democratic deliberation as a kind of special justification that would justify departing from the edicts of stare decisis. Put differently, as in Dobbs, an earlier precedent's arguable interruption of the democratic process on a sensitive or divisive issue might qualify as a special justification or consideration that would mute the force of stare decisis. A second possibility, though, is perhaps more alarming, that the court's invocation of democracy and democratic deliberation gestures toward an entirely new standard for stare decisis. On this account, a past precedent would not be entitled to stare decisis effect where its subject matter involves an issue that the court believes to be of high salience to the American people and where, in the court's view, the earlier precedent interrupted the prospect of democratic deliberation on that issue. Well, if that's the case, it begs the question. If stare decisis is now being reformulated with democratic deliberation at its core, what prior precedents might be affected by a court that is increasingly willing and even eager to identify special considerations that would justify departing from an earlier precedent? If the court's new vision of stare decisis is concerned with an issue's importance to the American people and whether an earlier opinion usurped the power to address a question of profound moral and social importance, as the Dobbs court noted, then it is very likely that Obergefell versus Hodges, the 2015 decision in which the court held that the Constitution did not permit states to restrict marriage to opposite-sex couples, is high on the list of possible next targets. Now, it is undeniable the court decided Obergefell during a moment of incredible churn in state marriage laws. As Chief Justice Roberts intoned in his dissent to the majority opinion in Obergefell, the Obergefell majority, quote, seized for itself a question the Constitution leaves to the people at a time when the people are engaged in a vibrant debate on that question, end quote. Now, of course, the present court is differently constituted than the Obergefell court was. But these personnel changes do not necessarily dispel anxiety about fidelity to past precedents. Indeed, they likely exacerbate them. Although Justice Scalia is no longer on the court, the Chief Justice and Justices Thomas and Alito comprise the core of a 6-3 conservative supermajority. Further, the addition of 3 Trump-appointed justices whose own views of stare decisis have affected significant changes in the court's jurisprudence in just a few years suggests that there is a strong majority that, at the very least, might be willing to consider whether the judicial resolution of marriage equality went too far, frustrating the will of the people. Now, of course, the Dobbs majority's interest in democracy and democratic deliberation goes beyond these jurisprudential concerns, and the majority's interest in restoring the abortion question to the democratic process goes beyond these consequences that I've identified for stare decisis. But at bottom, this question of democracy and democratic deliberation begs the question, what does the court mean by democracy? Its interest, its preoccupation with democratic deliberation reflects the view that democracy, rather than jurisprudence, is the best way to resolve this vexed question and perhaps other vexed questions. So the question remains for us, what is the Dobbs majority's vision of democracy? Well, as we explain in the paper, the Dobbs majority opinion suggests what the majority's vision of democracy is, and it is extraordinarily cramped and myopic. As an initial point, when the Dobbs majority discusses democracy, it does so with incredible institutional myopia, which is to say, the majority's opinion focuses almost exclusively on state legislatures, repeatedly invoking these bodies as the paradigmatic representation of democracy. Yet, we know that as a result of gerrymandering, state legislatures are often the least representative institutions in state government. More importantly, they are not the only institutions in state government. And the court's emphasis on state legislatures as arbiters of democracy belies the role that other actors play, including state judiciaries, which may play a role in interpreting state constitutional provisions to protect reproductive rights, as well as the role that state executive officials, governors, and attorneys general might play in enforcing and vetoing restrictive abortion policies. And critically, in many states, judges and executive actors run for office statewide, and they are elected by many more voters than the average member of the state legislature. Yet they are utterly absent from the Dobbs majority opinion, which focuses stubbornly on the prospect of the abortion debate being located in the context of state legislatures. And more importantly, in addition to this inattention to these other state-level constitutional actors, the Dobbs court conspicuously makes no mention of the prospect of direct democracy. Yet we know, in the wake of Dobbs, a number of states have used ballot initiatives and voter referenda to protect reproductive rights under state law. And when they have done so, even in states that trend red, there have been positive outcomes for reproductive rights, efforts to preserve and indeed enhance reproductive rights. The Dobbs majority's neglect of these other state-level constitutional actors and the prospect of direct democracy reveals yet another form of myopia, directional myopia. And by this, we mean that The court understands democratic deliberation of the abortion issue to proceed in only one direction: the further restriction of abortion rights. It does not even conceive of the possibility that state-level debate and deliberation might lead to the preservation or even the expansion of reproductive freedom. And that's especially curious, given the majority's repeated reminders that before Roe, debate was occurring on the abortion question, and proponents of liberal abortion rights had succeeded in some measure in persuading their fellow citizens of the rightness of their cause. Yet, when the majority talks about the prospect of this kind of deliberation, it only views it as restricting abortion rights further. Curious. The majority opinion is also myopic in its understanding of how politics works and indeed what political power might mean for certain groups. In this regard, we say it has a myopic vision of political power, which it reduces to the act of voting or perhaps running for elective office. Throughout the opinion, Justice Alito notes repeatedly that women are not without political power. When it comes to participation in election, women, he tells us, are registered to vote and turn out to vote at higher rates than men. You've come a long way, baby. But even if we put to the side the significant obstacles that women, who are often the primary caregivers in the family, must surmount to actually exercise the franchise, or, more fantastically, to run for political office, if we put that aside for the moment and just consider any metrics beyond simply voting or running for office, the empirical portrait that we use to measure democratic participation looks incredibly different. For example, if we consider basic representation in these institutions, we get a very different vision of women's political power. Women are grossly underrepresented in state legislatures and in Congress. They are also underrepresented in state and federal executive positions and in state and federal judicial posts. Women are also woefully underrepresented in the ecosystem that surrounds politics. They are a minority of federal lobbyists, and they donate to political campaigns at lower rates than men. Some would argue that this suggests that women have far less political power than their male counterparts. But again, to imagine this, you would have to have a broader vision of democracy than simply voting or participating as a candidate for political office. In addition to advancing this uncritical and facile vision of political power and its exercise, the court's vindication of democratic deliberation prioritizes and privileges moments of democratic debate that included only some members of the political community. And in that regard, it evinces a profound methodological myopia. For example, when the Dobbs majority insists that Roe interrupted state-level debate and deliberation of the abortion issue, it is referring to mid-century debates over whether to repeal or liberalize then extant abortion restrictions. What the majority fails to note, though, is that these debates that were undertaken at the state level were about laws and policies that were enacted through democratic processes that were categorically closed to all but white men. On this account, the debates that Roe preempted and that the Dobbs majority prioritizes and seeks to now vindicate were debates over whether to retain or liberalize laws that were enacted under conditions of extreme democratic deficit. Relatedly, the history and tradition method that the court uses to hold that the Constitution does not protect a right to abortion also reveals this methodological myopia. The Dobbs court's attention to history and tradition consists primarily of examining a slew of 19th century statutes enacted during a wave of nativist furor aimed at increasing the birth rate among native-born white women. And again, the laws that the majority cites were enacted in an era in which women couldn't even vote, much less run for political office. They weren't even understood as full and equal members of the polity. To put it differently and to underscore the point, the Dobbs majority's method of analyzing and interpreting the Constitution binds the contemporary meaning of that text to a body of law and authority in whose enactment and creation neither women nor people of color played any part. Let that sink in for a minute. We are prioritizing moments of debate in which those most affected by those laws did not participate. We are enshrining moments of constitutional significance in which more than half of our country did not participate. How is this representative of democracy? The Dobbs Court's hollow commitment to democracy is perhaps most evident when considered alongside the court's other interventions, which have actively distorted and disrupted the landscape of democracy. As we discuss in the paper, Dobbs arrives in the wake of a series of Supreme Court decisions that have blessed partisan gerrymandering, hobbled the Voting Rights Act, and have made our democracy decidedly less representative and less democratic. And we are seeing the impact of those decisions, not just in abortion, but throughout our country every day. When you look at the Tennessee 3 or the Tennessee 2 expelled from their positions in the Tennessee State House just a few weeks ago, that decision, that expulsion by a vote of 72 to 25 is only possible because Tennessee has a gerrymandered state legislature. And the act of expelling elected members of the state legislature who represent many individuals in some of the most populous cities in the state of Tennessee, that by itself is a profoundly anti-democratic act. And again, an act that is blessed by the decisions of this court, blessed and facilitated. With all of that in mind, let me now turn to the end and the post-Dobbs landscape. Because in my view, the most troubling aspect of the Dobbs majority's invocation of democracy is its cynicism, its deployment of the vernacular and values of democracy in service of an end goal that is decidedly out of step with majoritarian preferences that favor abortion rights. So what do I mean by this? In its dismantling of Roe, the Dobbs majority repeatedly referenced John Hart Ely's essay, The Wages of Crying Wolf. In Wages, Ely criticized Roe for lacking a foundation in constitutional law, but he did not stop there. Roe's other fundamental flaw was that, in prioritizing the pregnant woman, it failed to grapple fully with what Ely called the compelling interest in the protection of the fetus. Ely made the point even more plain in a telling passage. As he acknowledged, women, despite being roughly half the population, often lacked political power. Quote, compared with men, very few women sit in our legislatures. But Ely also noted that women's political powerlessness paled in comparison to another entity's profound vulnerability. As Ely intoned, quote, no fetuses sit on our legislatures, end quote. If the court's obligation is to use judicial review to, among other things, protect discrete and insular minorities who are powerless to press their interests in ordinary majoritarian processes, then Roe's vindication of the pregnant woman's rights, in Ely's view, left the fetus utterly bereft of judicial protection. And critically, this account of the fetus as an underrepresented, vulnerable constituency in need of the court's protection can be glimpsed in Dobbs. Throughout the opinion, there are repeated references to the fetus and acknowledgments that many among the public view the fetus as an unborn human being. The logic of the fetus as a person and abortion as murder has also been elaborated in the post-Dobbs landscape. Consider, for example, the recent opinion from Judge Matthew Kaczmarek in Alliance for Hippocratic Medicine versus FDA, where he repeatedly discusses the prospect of unborn life and refers to abortion as murder, starving the fetus of necessary support and sustenance. All of this, again, plays into the idea that the endgame here is the prospect of fetal personhood and the court's protection of this vulnerable entity. And perhaps most telling on this front is the Dobbs majority's discussion of abortion and its quote-unquote eugenic potential. In a footnote in the Dobbs majority opinion, Justice Alito reiterates a view long husbanded by Justice Clarence Thomas that those who seek, quote unquote, liberal access to abortion have been motivated by a desire to suppress the size of the African American population, end quote. To be sure, the Dobbs majority's nod to this abortion as racial genocide shibboleth is on some level gratuitous, given that the decision to overrule Roe and Casey rests instead on the view that the abortion right is unmoored from constitutional text and lacks deep roots in this country's history and traditions. But if it did not serve a jurisprudential purpose in the Dobbs analysis, that footnote serves an important discursive purpose because it builds the case for viewing limits on abortion as anti-discrimination measures for the fetus, and more importantly, for viewing the fetus as a minority in need of judicial protection. Critically then, the majority's interest in Ely's wages of crying wolf goes beyond simply allowing the court to reframe its actions in more politically palatable terms as a democracy-enhancing endeavor. It suggests the majority's vision of democracy and democratic deliberation on abortion will not end with simply returning abortion to the states, but rather with an acknowledgement of the constitutional interests of the unborn. In this regard, Dobbs's invocation of democracy, alongside these other discursive maneuvers, has the broader potential to reshape, however subtly, our understanding of who is in the polity and the identity of those discrete and insular minorities whom the court is obliged to protect. And there are hints that this is afoot. The majority's decision to focus primarily on principles of democracy rather than the illegitimacy of the doctrine of substantive due process, as Justice Thomas would prefer, may actually reflect a desire to preserve the possibility of later reliance on substantive due process to justify constitutionalizing a rule that would prohibit all abortions on the ground that the fetus is a person for purposes of constitutional law. And the court's repeated references to both fetal life and unborn human beings may be designed both to lay the foundations for constitutionalizing such a rule under the rubric of substantive due process, but also to broadcast both to litigants and lower courts the majority's receptivity to such claims. With all of this in mind, the Dobbs democratic state-by-state settlement is likely to just be a way station and not a final destination. Instead, the true potential of the Dobbs majority's vision of democracy-enhancing jurisprudence likely will only be achieved when the rights of an overlooked, discrete, and insular minority, the fetus, are finally recognized, whether through the distrustful politics of majoritarianism or our distrust and judicial fiat. Thank you.
Professor Murray is open to questions from the audience, so I believe we have some runners with microphones. They're making their way toward those whose hands are up. Yes, you're the one right here.
Me?
Yes.
Hi. It was a lovely talk. Great. I have a question. So the scholar Aaron Tang at UC Davis, who wrote an amicus, is making the argument that there's an originalist middle ground that the court can take on this question. I was wondering what your thoughts are on the legal strategy of fighting with the court we have instead of the court we should have.
So it's a great question. I'm a big fan of Aaron Tang. He always seems to try to find the middle ground. He's a middle ground kind of guy, I think, in a lot of ways. And I think that's admirable. He's very pragmatically oriented. And I don't think there is a middle ground for this court. The middle ground, I think, for this court was, in Dobbs at least, in the position that Chief Justice John Roberts was trying to take at oral arguments, where he was very much trying to sell his conservative colleagues on the prospect of merely upholding Mississippi HB 1510, which was the law at issue there, without overruling Roe and Casey. And to their credit, I think, the conservatives on the court made it pretty clear, both at oral arguments and then later in the opinion, why that middle ground was really like quicksand. Like, there was no way to actually uphold that law, which patently violated Roe and Casey and maintain Roe and Casey as viable precedents. And I think that's right. But that would be the middle sort of compromise ground, the kind of compromise that you saw in earlier cases like 2020's June Medical, or even Planned Parenthood versus Casey, which, for what we think and say or what we hear said about Casey today, Casey was very much a compromise position that really limited abortion rights in a profound way. I mean, this was not the liberalization of abortion rights that it's been made to stand for today. So I appreciate Aaron's desire to sort of seek a middle ground, to thread a middle ground. I don't think that's the court we have. That middle ground fantasy court has Merrick Garland on it. That's not the court we have today. What we have is a quite extreme 6-3 conservative supermajority where the middle is Brett Kavanaugh and the Chief Justice. And if you think about it in that way, I think you understand what I mean. Like, that's not the middle, that's the right? The middle is the right. And so I appreciate where Aaron goes with all of this. I don't agree. Hi, Jim. Well, I know him. That's Jim.
Hi, Melissa.
Hi.
Fantastic talk. I'm Jim Fleming. I teach in the law school, and I'm also on the graduate faculty of political science. So I think you're spot on in every respect, and confirm and add to my worst fears about the Dobbs opinion. But I actually wonder why Alito even, I would have expected him to fudge what the democratic process is more than he did. I would have expected him to say, leave it to the democratic process, as in the Republican majority in Congress can now outlaw abortion nationwide. And I also thought that all of the sources he cited as of 1868 for the proposition that there was no right to decide whether to terminate a pregnancy that was part of the original meaning of the 14th Amendment, I would have expected, I think he's laying the groundwork there for saying, oh, and those same sources support a presupposition that fetuses were persons. So which do you think is the more likely route? To go that route, to kind of take all those sources and push them further, or to go the fetuses are discrete and instant minorities? Because the court has had no interest in recognizing any, quote, new discrete and instant minorities for over 50 years.
So it's a terrific question. Let me fudge it a little. I don't think they're mutually exclusive, right? So it's true the court has not recognized a new suspect or quasi-suspect class since, I think, illegitimacy in the 1980s, when it finally denominates illegitimacy a quasi-suspect class. But I don't think that you actually have to say the fetus is a discrete and insular minority in order to enshrine the fetus as a person for purposes of constitutional law. And that's just sort of the divide between equal protection and substantive due process. And to your point, I think it's quite telling that despite Justice Thomas's concurrence, in which he's like, oh, by the way, I do think Obergefell's on the table, and Griswold and Lawrence and everything else except Loving as well. It's a diatribe against substantive due process that the majority does not take up, right? And I think that's the tell. They don't, it's almost like they're keeping it in abeyance, because that actually might have to be the doctrinal route to constitutionalizing the fetus, whether it's in 5 years or 10 years or whatever. It likely will happen under the rubric of substantive due process, and I think that's why he doesn't take the Thomas bait. And I think Justice Thomas, happy to be alone on this, happy to make that point that he doesn't believe there's anything substantive about due process and no rights might flow from it. So, I don't think it necessarily has to be the case that it proceeds under sort of a formal equal protection logic, and we include the fetus as one of our sort of Caroline products footnote for discrete and insular minorities. I think you can still have that kind of notion, even if you're working under substantive due process. I think there are some other precedents may be called into question, but still sort of do that kind of work. Lawrence, for example, I think does a lot of that work, never denominates sexual orientation a quasi-suspect or suspect class, but nonetheless talks extensively about what the lack of dignity, the lack of liberty for individuals who are gay means for the prospects of equal protection. So I think that kind of imbrication of substantive due process and equal protection that Justice Kennedy really pioneered could be turned on its ear by the conservatives when they deal with the fetus, and they will deal with the fetus.
Hi, Melissa. Thanks for a great talk. So I just taught Dobbs a couple days ago, actually.
I'm sorry.
Yeah, I know. It's the first time through. It was awful. And one of the things that my students were focusing on, in which we brought through from the Obergefell decision, was this idea of neutrality. That is, Kavanaugh's concurrence in Dobbs focuses a lot on this idea that we're just being neutral. And so what I just want to extend your argument a little bit about democracy and say that I think there's actually even more, just pile on a little bit more, that there is a cloak, they're wrapping themselves not in a cloak of democracy, but a cloak of this idea of neutral principles, which of course goes back to Charles Black and desegregation and segregation. Right. So there is this, I think there's a self-consciousness about the way they're thinking about what they're doing, and then they're trying to deflect what they're doing by saying that it's neutral. And in fact, Roberts does the same thing in his dissent in Obergefell. Yes. But he's moved in Obergefell. In Dobbs, he's discarded this idea of neutrality. In Dobbs, he actually commits to a quasi-substantive due process position, I think, in the reasonable time to wait. So I guess I just wanted to hear what you thought about, like, what is the connection between the idea of neutrality and the democracy that you're talking about? Because democracy is a value, it's not a neutral value, it's one value among many, and I'm just wondering if there's a way to spin it that fits with your story, or that it's an alternative, actually, way of being even more cynical about what they're doing.
That's a really interesting question. We talk a little bit about the Kavanaugh concurrence, and I think the way you framed it is a self-conscious enterprise is especially pronounced in the Kavanaugh concurrence. Like, he cares what you think, right? He's the father of daughters. He cares what you think on this. And I think that's a big part of why you get this very sort of pained exegesis about, the Constitution is not pro-abortion, it's not anti-abortion, it's neutral on this question of abortion. And he associates that neutrality with letting the political process take this. So there is a way in which I think Kavanaugh, maybe more so than the majority opinion, understands democracy to be neutral, right? Which is an interesting kind of perspective in and of itself. Majoritarianism, if that's what you think democracy is, and I think that is a big part of what the majority thinks, as neutral. Like, that's not neutrality. But that's, I think it's really about this idea that the court isn't supposed to insert itself into these things. Like, the court is to remain neutral. And that's an interesting kind of posture as well, right? It's certainly in the context of equal protection with Caroline Products and footnote 4, certainly in the context of the protection of fundamental rights in the substantive due process arena. But I think he understands neutrality to have two valences, right? So it is neutral when we let the people decide this, because we are neutral and we're not deciding it for them. And that comes out a lot. I think you see it as well in the dissents in Obergefell, certainly in Lawrence. I think Scalia's dissent in Lawrence is not necessarily framed in the language of neutrality, but this idea that the court has put a thumb on the scale. And indeed, I think he says that at the end of the dissent in Lawrence when he talks about how the court has been captured by the legal academy and the double ALS, if the double ALS even had this power, like, to capture the court. But he talks about that. That's not neutrality, that's capture, right? If the court were being perfectly neutral on this issue, it would not be lining up on the sides of the elites, right? And wouldn't be playing this sort of Knights Templar role. And again, the invocation of that sort of imagery of the court as a knight riding in to vindicate the interests of sexual minorities, I think you get a similar kind of image in Dobbs, only this time it is the court as the Knights Templar riding in on white horses to vindicate this question that has been improperly taken from the people. Like, that's the neutral position.
Hi, thank you, Melissa. Talk was great. Michael Ulrich, I'm at law school, and SPH. I wanted to play the role briefly of white guy pushing back on your ideas a bit, and and say, is fetal personhood the end game, and is it actually something bigger, right? And is it control? Is it actually going back? And I'm thinking about it in the context of Second Amendment rights, the fight over gender-affirming care, extreme protection of religious rights. And so can we actually take it bigger, right, and say that there actually is a different end game, and that fetal personhood is the end game here, but that's one of the prongs to that? So
Michael, I'm happy to have you push back. I'm always in favor of taking this bigger. I do think this is about control. Right after the Dobbs opinion was announced, I wrote an op-ed in the New York Times called, they wrote the title is grammatically incorrect. It was like, Americans are losing their right not to conform. And I think that is a thread that you could sort of use as an overarching principle to think about all of these developments from the court, this idea that those who don't conform to whatever this sort of dominant vision is, whether it's Christian nationalism or a woman's understanding of her role in the home and outside of it, that there's no room to be nonconforming. I think that's a big part of it. But what is so cynical and problematic for me is that a lot of this effort to limit the prospect of nonconformity comes on the backs of the court sort of harnessing the language of minoritarianism to advance whatever this agenda is. So for example, in the context of the Second Amendment, it's not enough to just expand the Second Amendment because you think the militia clause is mere surplusage. Justice Thomas has written an entire meditation on how the expansion of the Second Amendment is necessary to repair the injury done to Black men during the period following the Civil War, when states refused to honor the civil rights of newly freed slaves by allowing them to keep and bear arms. And the decision to disenfranchise them from that right left them uniquely vulnerable to these episodes of racial violence. He's done this twice in 2 Second Amendment decisions. It's definitely in the Bruin opinion, which was announced a day before the opinions in Dobbs. It's also very present in his concurrence in McDonald versus City of Chicago. But it frames this idea that we're all now going to conform to the NRA's vision of gun rights around the idea that this is necessary to further racial justice, right? The association of abortion with eugenics, I think, does a similar kind of thing, that we're going to withdraw this long recognized fundamental right, in part because to acknowledge it is to further the possibility of racial genocide. That is Justice Thomas's view. And again, the limitation on women not conforming to this particular role, wife, mother, is wedded to the vindication of this notion of racial repair, right? Racial justice. If you think about Kennedy versus Bremerton School District, this is the praying football coach. So Coach Kennedy is a public official. He's a public school coach, but his body is literally rendered private space. It's a temple, as long as he's praying, wherever he's praying. And again, the court sort of frames him as this individual and his choices as being besieged, right? So, I mean, they're transforming a white man who is a public school coach into basically a minority besieged by the state and its championing of anti-establishment. I mean, it's just a very weird move where we withdraw rights from women, and especially women of color, in the name of racial justice. We subject gun-scarred minority communities to more gun violence in the name of racial justice, and we make this white coach a minority for purposes of religious freedom. And yet, I think in about, 5 weeks, we're gonna withdraw affirmative action, again, in the name of racial justice. So there's a weird inversion going on. And I've been tracking it for a while. I think we saw it in Masterpiece Cake Shop, where Jack Phillips, the Christian baker who did not want to provide cakes for same-sex weddings, he's discriminating against same-sex couples, but he is recast as the victim of discrimination himself by the court. And so, I mean, you've got to really sort of think about, like, the larger end game is harnessing, I think, the gains of the Warren Court in the 1960s and that liberal progressivism to repair racial injury. We're now using that language of racial repair and that understanding of minority status, only we're recasting individuals we would have understood as members of a majority as minorities in order to do it. And we're using the Second Amendment and abortion rights as means of furthering racial justice, but we won't use the Equal Protection Clause as a means of doing so. I mean, it's just completely topsy-turvy. And so, yes, I think we should go bigger. I love going bigger. Let's go bigger.
Hey, my name is Stephanie, and I'm wondering if we have a history, right, of seeing the court as being careful with its reputation in terms of how populist it may be. But is there any upside to, or maybe more cynically, any dangers of the court instead positioning themselves as actually a part of an outcome of the process of democratic deliberation, right? They are appointed, but because someone has been elected president, because senators have been elected, right? It is, in a way, their positions are an outcome of a process of deliberation, and they can be removed through processes of deliberation.
So I think this is an even bigger question than just, if the court is associated with particular ideological positions or groups, like, say, the Federalist Society, for example, or a president, is there some good in that, and sort of knowing it? Does it shape their behavior in a particular way, or are they more careful understanding that? I think, is that sort of the tenor of your question? Yeah. I think it's a great question for this moment. I mean, we've seen over the last couple of weeks, like, there's been a lot of discussion about whether or not the court has been captured by, whether it's dark money or particular ideological viewpoints. There's been a lot of that. I think if anyone is most concerned about this, it's got to be the Chief Justice, who earlier has famously said there are no Obama judges, there are no Trump judges, there are only federal court judges doing their level best. And he really wanted to hold on to that. I think it's harder to hold on to that in an environment, and I think he understood this when Dobbs was announced. I think he understood that it's harder to hold on to that vision of neutrality, if you will, in a world where everyone seems to understand that a decision that was long hoped for by one sector of the public is only possible because a justice died and was replaced by a justice who did not share her ideological priors. And I think that was very clear from Chief Justice Roberts and his attempt to broker that kind of compromise in Dobbs. I think it was also clear that the dissenters understood it. They said so in the dissent in Dobbs. They're like, there's no reason we're here dissenting except for the fact that our numbers are different. Like, there's been a personnel change on the court. I mean, your question goes to this larger existential question about what is the role of a court in a democracy, right? Is the court's role to ratify majoritarian preferences? Is the court's role to ratify the preferences of the political party that appointed the majority of its members. That hasn't been the role we've expected of the court before. Maybe it is now, and maybe we'll see some real consequences from that. I mean, like right now, the fact that we're talking about a new code of judicial ethics for justices and possibly, subpoenaing the Chief Justice to come testify before Congress suggests that the jig might be up, right? Like this is a profound moment for the court. This is a profound slight to the court's legitimacy, if you will. And I don't know what the outcome is going to be, but it definitely seems clear that they should be worried about it because the court, more than any other branch of government, depends on the public viewing them as above the fray, right? The court does not have the power to command an army. It doesn't have the power of the purse. There's no reason we should follow what the court says, except that we believe the court is legitimate and that when they say something, they're doing law. When we stop thinking it's law and it's just vibes or whatever, that's when the court's lost. And I think some of them know that. I don't know how many of them know that or how many of them understand that they've lost some measure of the public. But I think the fact that we are talking so much about the court, more so than I think we ever have, suggests how much has been undercut in recent years.
So I am not a lawyer, I'm an historian, and not an historian of law. So I will talk like a common citizen. What can I, as a common citizen, do that could change the situation? You mentioned going big, let's go big, but you were talking from the point of view of a legal scholar, someone in the legal system. But as a citizen, what can I do?
So I get this question a lot, often from students who feel a little beleaguered, like what can I do? I voted and nothing's different. I voted and Dobbs overruled Roe and Casey. I'm gonna say you need to participate in the political process. And that could be voting, that could be a lot of things. I think we all need to think about democratic participation in new and different ways. Like it's not simply voting, maybe it is running for office, but more importantly, it's not just what we've thought of. Like, 2024 is coming and we'll all think about the presidential election, but we have to think about every election. The profundity of the malapportionment that has happened in the electoral landscape as a consequence of the court's decisions, as a consequence of individuals really focusing on state and local government as means of consolidating ideological authority, we have to show up all the time, and we have to show up in huge numbers in order to overcome the malapportionment. And that's exhausting. I mean, I don't know what else to say. Like, it's exhausting, I'm exhausted thinking about it, but I know that's the work that has to be done. We can't afford to just focus on the presidency and, every 4 years we have to think about midterm elections. Like, if the Democrats had lost the Senate, there would have been bills to make a statutory prohibition on abortion. It might not have gotten past the president, it might have been vetoed, but there certainly would have been attempts to write a law that would have effectively made a statutory finality to the Dobbs decision. If Congress changes hands in 2024, that will happen again. If the presidency changes hands, that will likely be approved and enacted by President Trump or President DeSantis. Right, so all of those elections matter, the midterm elections matter, but more importantly, the down ballot elections matter. Right, we're like living in sort of hand-to-hand combat at this point. Like, it matters who the district attorney is in your county. If people are suing women for helping their friends seek abortion care, it matters who the judges on your local courts are. I mean, we just had an enormous election in Wisconsin, of all places, because that seat turned the whole Supreme Court of Wisconsin in a different direction, and they're now going to be able to make decisions about partisan gerrymandering and reproductive rights that they would not have been able to do in the same way a year ago. That matters. Like, all of those down ballot elections, like, all of those things matter. So, what can you do? be attentive, be engaged, encourage your students to be attentive and engaged. Every single election is an opportunity on both sides, and we can't leave any power on the table. We've left power on the table for years and years. That's why we have school boards saying that we can't talk about history. It's why students in Florida think that Ruby Bridges is just some lady, as opposed to someone who literally integrated her public school. We're gonna have more and more of this, and it's all gonna be local, it's all gonna be at the state level. We can't just focus on who the president is. It's a big part of what's going on, but it's not the only part. So yes, get out there, run for school board, run for the things. I tell students, going to Cravath may not be your highest, best use. Cravath is a big law firm. Maybe your highest and best use is going back to Port St. Lucie, Florida, and running for school board there and literally inserting some rationality into what's going on. Maybe that's your highest and best use. Maybe it's taking a whole bunch of people with you. Again, we've got to think about all of the different ways, because they've run the tables on us. And if you want to turn that back, you're gonna have to run the tables too.
Hi, I'm going to ask another history question. So I'm Betty Anderson, I'm in the history department, and I taught the historian's craft last semester, and I brought in Dobbs and New York Rifle, that case. And I focused particularly on the history. So maybe just get an examination. You talked about the quality of the history analysis there. How is that going to be used, weaponized in the analysis you're giving us?
So let me just first say, I was a history major in college. I didn't go on to get a PhD. I've taken some methods classes. Doing good history is hard. It's really hard. So I'll say that. So my hat's off to everyone who is an actual legitimate historian. No one on the court is an actual legitimate historian, right? They're not. And so that ought to give us pause, right? And you see that. And Justice Thomas, actually, sometimes I love Justice Thomas because he says exactly what I'm thinking about him, but he just says it like he doesn't care. So in the Bruen opinion, he says, not all history is the same. Which is only the history I like. And that's what he does. He does it with regard to abortion. He sort of cherry picks the history to create this narrative that Margaret Sanger, who was a birth control pioneer, had nothing to do with abortion, but that she's a eugenicist, and therefore abortion has eugenic potential because it's associated with reproductive rights. It's a completely wackadoodle historical, patch-up job, but it's now been exported throughout the lower federal courts, and now it's in a footnote in Dobbs. That's the kind of history. It's sort of cherry-picked, it's selective, it's itinerant. You see the same thing happening in Bruen. There were a number of historians who filed very good briefs in Bruen talking about all of the different ways in which public carrying of firearms would not have been permitted at the founding. But not all history is equal. Just the history I like. And so we're seeing a lot of that. I think we're going to see a lot of that. We're going to get a lot of history in this affirmative action case when we're talking about what the original intent of the 14th Amendment was. And I think there are a lot of good arguments to be made that the 14th Amendment, which was part of making newly freed African Americans part of the body politic, probably was race conscious, maybe a little. We're going to hear a lot about how there are certain histories that suggest that this was intended to be race blind on its face. And again, it's hard to do good history. I think it's even harder to do it when you're not an historian. And I think we're going to see that. I think this person, Carlton Reeves, who is a judge on the Southern District of Mississippi, is a hero. He's a judge, he was faced with one of these, I think it was a gun rights case, and he was like, I'm not an historian. The court says I'm supposed to do history and traditions analysis. I can't do that because I am not an actual historian. And so he appointed a special master. And I hope other judges will sort of signal that. The enterprise itself requires sensitive judgment and training. which these judges don't necessarily have. I mean, and again, for years, I've heard IP scholars talk about, like, you know, it's nuts that we are allowing federal judges who can't even program their phones to decide IP cases, intellectual property cases. Same idea here, like same idea.
Thank you all for coming. Thank you for your good questions. Join me in thanking.
Thank you. Thank you for your patience.